Call to order the February 2nd Board of Adjustment meeting. Please turn off your cell phones and other electronic devices if you haven't done so already. First order of business is approval of the minutes of the January 19th, 2012 meeting.
Move to approve.
Second.
I will abstain because I was absent. Please register your vote. Would you shut off, Rod? Minutes are approved. Continuance requests and withdrawals from staff.
We have one continuance today, item number 6, case number 13509, request a continuance to February 16th.
We have a motion. Anybody to speak to that case from the public? Hearing none, I would entertain a motion.
I'll move the continuance.
Second.
We have a motion and a second. Register your vote. Continuance is approved. Do we have any continuance requests or withdrawals from the public?
I'd like to request a continuance to 13504 as the opposition.
Could you step to the microphone and elaborate, please? And give us your name and address for the record.
My name is Marshall Hugas. I live at 4100 Southeast 86th Place in Bradford Place Estates, which is directly adjacent to the southern edge of the 40-acre lot, residential zone 1, that is under discussion. And I believe that with the other 6 wells that are going to be addressed at the 16th February meeting, that it would be more appropriate to address this rig at the same time as those, because it is the same company and it is the same neighborhood that is directly impacted by all of these.
And you're requesting a continuance to what date?
To the 16th of February, which is the, I believe, when the other rigs are scheduled to be on the agenda.
What we're discussing is whether or not the issues will be common to this. And
They will be common, and additionally, the concerns and the impacts, I believe, are common.
Mr. Walker, do you have a position on this motion for continuance?
I do.
Can we excuse you and allow Mr. Walker to speak to the board, please?
Stevens and Johnson is asking that the motion to continue be denied. As this board is probably aware, this matter was on your docket 2 weeks ago. Mr. Hugas was here, asked for a continuance. We agreed with that. We, that afternoon, met Mr. Hugas at the site of Stevens and Johnson's drilling activity north of their addition. We spent about an hour and a half with him out there talking about this. Then a week ago today, there was a homeowners meeting at Bradford Place Estates. We attended that. The 3 gentlemen here representing Stevens and Johnson and I attended that homeowners meeting. Then we had a meeting among my clients and me after that meeting. Then I prepared what I would call a proposed agreement between Stevens and Johnson and the Homeowners Association, and provided it to them on Monday, and apparently they found it unacceptable. They sent back to us what they considered to be an acceptable agreement between the homeowners and Stevens and Johnson, and we found that unacceptable. We have a drilling obligation on a farm out from British Petroleum, BP, on this well that I think expires March 17th. And so we need to have this hearing so that, if the application happens to be granted, we could proceed with the drilling operation. And so therefore, I mean, we think we've done what can be done to negotiate with respect to this particular well. It has very little relationship to the other wells that are on the docket in 2 weeks. Ms. Talley and I have spoken about that. She could probably speak more about why those matters are back on the docket after they were already approved. But we would like to proceed with this matter now.
Is there a drilling rig that's been hired and is available to begin drilling this well?
They do have a contract with Dan Darling Drilling, to commence drilling before the 17th.
Mr. Hugus, could you come back to the microphone? I was down in your neighborhood and around this site, and it appears to me there are already some pre-existing wells.
That's
North
correct.
and northwest.
Those are the ones that are to be addressed at the 16th that were inappropriately begun without following the proper protocol, allowing for opposition to be presented prior to their initiation.
But, I mean, what possible recourse, could they have, on those wells? I mean, they're going to force them to take?
That's actually my concern about this one as well, that once the oil drilling begins, we have lost any opportunity for recourse as the homeowners association and homeowners that have invested $5 million in that neighborhood, and now because operations have begun, we no longer have recourse unless we can negotiate an agreement with them or pursue legal alternatives. So, in my opinion, everything here is associated directly and intertwined, because if you allow them to proceed with drilling without addressing all of them together, then again, you have set the precedent that if they have assets in place to begin, then us as homeowners and individuals that are most directly affected, we lose the opportunity to try and get some type of, we lose the opportunity to present the opposition as a unified package, because that's really what it is. All of the property is R1 zone land, and all of the wells that are already initiated up against our property lines. Again, we weren't here and did not have the opportunity. We were not even notified prior to the initiation, much less the council meeting, that this was taking place. And as a result, we now have 2 operating rigs that never had the proper protocol of public hearings with full representation taking place.
And when I was there yesterday, I think I saw 4. One of them looked like it was not operating, that was more west of you. It's kind of directly east of the trucking company where they have access.
Right. If you go further west into the industrial zone, there are additional wells in that area. Again, because it's an industrial zone and not even in near proximity, relatively speaking, to the Bradford Place Estates, we were never advised, inquired, notified of those, but our objection is to those that are in the residential zone directly north of our subdivision.
And I don't know what the notification requirements are and what the range from your neighborhood is, and so I don't know whether...
The city statutes require that for all 6 that are already in place, the 2 that are already pumping, that our neighborhood be notified, at least those individuals that are within the lethal radius of those wells, and not one of them was notified.
And you're saying they are within the legal radius of
Yes, sir,
the
they are.
notification was required?
Those other ones are.
Yes.
And the clerk can confirm that notice was properly given for the one that's on the agenda today.
What's on the agenda for the 16th?
The 6 wells that were previously approved,
Yes?
but they didn't have proper notice.
Okay.
So we've sent new notice, and they're coming back to you on the 16th. This one today, we have proper notice on this one.
And how long have those wells been in existence?
A year?
And have there been any incidents with those that have been reported?
Not that we're aware of.
We have, in fact, presented complaints to the oil company, which I would have to defer to the individuals that were most directly affected and presented those complaints to the company and what their response was. But needless to say, if they were more receptive to us, then we wouldn't be here today.
Chairman Austin, I would suggest that we keep this on the agenda today, that we hear it. We can always entertain a motion for continuance after we hear both sides make the presentation. The thing that I have great concern about is that there's a farm out agreement that's about to expire in March, and the difficulty in obtaining a drilling rig, that's not the easiest process in this economy. And so I think we ought to hear it and reserve the right to reconsider a motion for continuance after both sides have made their presentation.
Since we've got a call for continuance from the public, does it require a motion on our part to go ahead and hear that today, or?
It requires a hearing on his request. So you've decided, you've discussed it.
I would move to deny the continuance request at this time.
Okay. Second. I have a motion and a second to deny your continuance request today for this first case. Register your vote. Your continuance request is denied, sir.
Item number 1, case number 13504, request for use variance of Stevens & Johnson Operating Company for permit to drill an oil gas well and a variance to the required site-proof fencing around the well site and landscaping located at 8523 South Sunny Lane Road.
I'm Russ Walker. I represent the applicant Stevens & Johnson. This argument may take a while. I noticed there are only 5 cases behind us. If I would propose that we could go last if you want. I'm not sure that the homeowners want to do that, but if the other people want to get in and out of here before we start a long argument.
You know, I was absent last meeting, but I have watched the hearing and I've been to the site, so let's go ahead and hear it.
Okay, that's fine. I just was, if other people want to get out, that was what I was going to propose. Do you want me to go first, or do
I want you to go first.
Okay.
You met with the homeowners association. What was the gist of that meeting? I mean, they expressed their concerns and what they would like to see, and you
Correct.
found common ground or did not?
Well, apparently we didn't.
What do they want? What does the homeowners association, what are they asking you for?
A lot of money.
Be more specific. Do they want landscaping? Do they want...
I have copies of both the proposed agreement that we submitted them and the one that they submitted back to us. If I can hand you those.
I don't think so. Just, if you will, just summarize.
I can try to summarize them.
I mean, are there complaints? Do they want fencing? Do they want landscaping? Do they want noise reduction? What is it they want?
Well, I think they want all of those things. They want, and we had actually proposed this, and they've sort of expanded it beyond our proposal. We offered to put any family in a hotel at $150 a night within a certain distance from any well being drilled during the entire drilling procedure. And they then asked for more than what we had proposed, and then we proposed to basically pay the homeowners association. Apparently they have some problems with their street, some problems with the gate into the homeowners, into the residents, into the neighborhood, a few other things that they needed. We proposed to pay them $10,000 per well drilled. We're actually, as you know, including the 2 that have already been drilled and 4 more that have been approved on that pad, the one that's going to come up next Wednesday, or next 2 weeks from today, and then the one we're proposing to drill here, and any other well that we drill on this 40-acre tract, which we happen to we own the surface of that 40-acre tract ourselves. We proposed $10,000 per well, and then they wanted $30,000 per well.
What I want to know is what do they want related to those sites? They, first of all, they want, because they're in R1, they want them denied. The second of all is, they want reasonable screening and landscaping. One of the letters that I've got in protest, talks about the gases and the other fumes that might be emitted. Aside from what they may be trying to negotiate to improve the neighborhood, what do they want from the well side?
Well, again, I think they want sound and sight abatement. And I could read you the paragraph that they wrote in their proposed agreement that would detail what it is that they want. If you'd like me to do that, it'd probably take about 60 seconds.
That's fine.
S&J will construct a site-proof fence on the top of an east-west trending berm, which it has constructed between its E&P activities and Bradford Park Estates. The fence shall be a minimum of 8 feet in height from base of fence to top. S&J shall be obligated to maintain fence in good condition and an attractive state. The fence shall be sufficient to screen from view the well pumping equipment and to provide as much of a noise barrier as possible. Prior to construction, the homeowners association shall approve the type of fence to be constructed and ensure that the fence is sufficient to satisfy the purpose of this paragraph. S&J will plant evergreen trees between each pair of existing trees which is as previously planted on top of the east-west trenching berm which it has constructed between its E&P activities and Bradford Park Estates. The evergreens shall be a minimum of 8 feet in height and have sufficient size to screen from view the well pumping equipment. Shrubbery may be added to aid in the screening. The planting will occur at an appropriate planting time during the planting season following the execution of this agreement. S&J will use its best efforts to assure that the planted evergreen trees survive and grow and will replace trees which do not survive. The Homeowners Association shall approve the type and amount of vegetation to be planted in order to satisfy the purpose of this agreement. That was their proposal back to us. And my paragraph to them is about a third of that. I could read you what we proposed to them if you'd like to hear that.
Did you respond to that proposal that you just read?
We did not.
Okay.
We did not get it until last night about 10 o'clock. And we have not. Here's what our...
And one other question real quick. This well, how long will it take to drill? How deep is it going to be drilled to?
It will take between 10 days and 2 weeks. And let me point out that if you see on the screen up here, you see where the crosshatch area is, that's their addition. There is a big power line that runs just north of the north border of their addition. I've got pictures of it that goes through there. There's a big power line easement. Then there's an OG&E underground easement north of that goes pretty much up to a pad that we built to drill these wells that will become an issue 2 weeks from now. So my client built a berm, about an 8-foot berm, and then has planted trees on it, which will grow to about 35 feet in height on top of that. And then we came back, and that's the berm we're talking about. And here's what we proposed. S&J will plant evergreen trees between each pair of existing trees, which it has previously planted on top of an east-west trending berm, which it has constructed between its E&P activities and BP and Bradford Park Estates. The planting will occur at an appropriate planting time during the next planting season following the execution of this agreement. S&J will use its best efforts to ensure that the planted evergreen trees survive and grow and will replace trees which do not survive. The purpose of this paragraph 1 is to provide a sight and sound barrier between S&J's E&P activities and Bradford Park Estates. S&J will choose a type of evergreen tree which will further that purpose. And let me say also that these pumping units are about 30 feet tall. So it's difficult to completely screen out an entire view of the pumping unit. You have to have some very mature, tall trees to do that.
Mr. Walker, let me excuse you. I'd like to speak to Mr. Hugus again,
Sure.
please. I'm calling on you because I'm assuming you're speaking for the neighborhood?
No, sir. Actually, my wife is the Homeowners Association president, but I was the only one that was able to make it at the last meeting. So, but I've been at all the meetings. I've talked with them. I've been at the Homeowners Association meetings and discussions. But I'm more than willing to entertain.
You know, my inclination is to look at the case that's before us today. The notifications were made. I don't know about the notifications that on the other sites, and to me, that's a separate issue, and one for you to, deal with in a different venue. I can't say, I understand as a resident in a neighborhood, that you care about your neighborhood and you care about what goes on around you, and I compliment you for, the time and the trouble that you've taken and the other neighbors to address this and to show that concern. I can't say that I'm particularly happy to hear that you're trying to negotiate a financial settlement, to make improvements in your neighborhood.
But no, sir, his perception of why we're negotiating is completely off the mark. We've already had 2 homes directly affected financially by the placement of the existing wells that are now pumping. One home was sold at roughly $20,000 below the initial value that went on the market. Because of the pumps on site, a number of prospective buyers, as soon as they saw the pumps in operation, immediately turned and departed the area. Another home that is directly affected, one of the opposition today, that's here today, they had appraised their home for mortgage refinancing prior to the pumps going in, and since then they have had it appraised for a lower interest rate, but the mortgage value came back at $16,000 in 1 year, solely because the difference being the pumps are now in place pumping.
And that may or may not be the case, but it's not really, as part of our consideration today. It may be, but if you go back and you prove that you weren't properly notified and there's some recourse available to you on these other units.
I believe it was actually the city council or the city attorney that notified S&J that, in fact, those proper notifications were not made, and that is why it is on the docket for the 16th.
But what's before us today is whether to allow the drilling and whether, basically, to allow the gas inspector to make the call in terms of what appropriate screening would be. And what he's going to look at is he's going to look at, the context of the whole area. He's going to look at proximity to your neighborhood.
And that is why, in my opinion, they're directly linked to each other, because if we can get them to agree with the existing site and reach an agreement there, that would not only take care of that site, but it would also take care of the other site.
Sir, do you speak on behalf of the homeowners association, or are you just an individual?
No, I'm here speaking as an individual.
Right.
That is a participant in the homeowners association. And to further clarify, there were 2 agreements. His was given at late Monday evening, which prohibited any meeting by the homeowners association meeting about it until the following night. And then after we met and discussed it and discussed modifications to it, we had the opportunity to present it to some attorney friends on Tuesday, which after we got their feedback, we then turned it back to him. And because there are those 2 documents out there, I believe that we could come to an amicable agreement of some sort, given the opportunity to actually discuss it.
The homeowners association has consulted with an attorney, and you are aware of the existing case law that's out there dealing with variances?
The homeowners association has not. Individuals in the homeowners association have.
Do you have any interest or the ability on behalf of the homeowners association to take a break and visit with the applicant and see if you can come to some resolution before we take a vote?
Since everybody's here, there's no harm in stepping out and trying to discuss.
I think we'd be more than happy to put this at the tail of the docket to give you guys a chance to discuss this and try to come up with some resolution on your own. But I think the board is probably prepared to vote on this issue today.
I understand that, sir.
I'd make a motion that we put this at the tail of the docket and give the parties a chance to negotiate.
Second. I have a motion and a second. Register your vote. You are adjourned to visit amongst yourselves.
Item number 2, case number 13510, request of Quail Ridge Sporting Clays for a variance to the hard surface paving requirement located at 7632 Southeast 149th Street.
Mr. Chairman, I need to excuse myself from this.
Thank you. Is the applicant present? If you would, your name and address for the record, please.
My name is Dave Martin. I reside at 3109 Oak Brook Drive, Dell City.
Tell us about your application.
Well, we have been working on this site for about 3 years with Councilman White and other entities within the city. We have been approved through the Water Trust to lease 263 acres to put in this sporting clay facility. Everything is going as planned. We initially had a site plan. We had reached, city code says that we have to have so many paved parking spots per, but the nature of this is that we're out in the country, it's way out there, kind of out of the way, and the pavement actually would cause probably more runoff than the actual gravel, which I'm proposing to use the black asphalt millings, which they do harden up, but yet they permeate water through them, which would help further runoff in that area, because this is on the very south border of your Elm Creek addition. Other than that, I'm willing to do whatever I propose, that we still put in hard surface for handicap accessibility right near the building. We were required to put in 2 spots for that, and we would go ahead and do that, just because I know it would be hard if we did have wheelchairs come out to get in and out on that anyway, and then we would extend our apron a little further in than required by code, just so we make sure we have a good apron off the street.
Could you tell me what the duration of your lease is?
25 years.
Okay. And did you just initiate it?
Yes, we did it in, I believe it was November. We've been working, July this land came open. It's owned by the Water Utilities Trust. It was just an old farm that went back in. I guess they reclaimed it. I've cleaned it up. I've redone the house into commercial standards for an office. Built the pavilion. Permits should be finalized. We should be doing our regular occupancy next week.
So is construction or have improvements been made to the property? Or?
Yes, sir.
Okay.
Yes, sir.
Okay.
I'd like to make a motion for approval based on having satisfied the statutory requirements enumerated under the favorable conditions in the staff report.
Second.
We have a motion and a second. Register your vote. You are approved.
Thank you very much.
Will somebody let Mr. Allen know that...
Item number 3, case number 13511, request of the City of Oklahoma City for a variance to the maximum walkway light fixture height located at 613 South Lincoln Boulevard.
Good afternoon, Tim Johnson with Johnson Associates. We are actually representing the City of Oklahoma City in this case. This is the extension of the canal to the river project that has been under design for a number of months. It's located south of the existing canal, just north of the relocated I-40. As you know, there's a bridge underneath the I-40 highway that's just recently been opened. The purpose of that bridge is to connect the river for river cruise boats to come up into the canal area. This box is the project limits. This dashed line is the scenic river overlay limits. So half of our project is in, half of it's out. Both sides of the project where we're connecting currently have the Esplanade fixture, which is this concrete light pole with a ornamental teardrop fixture on it. The north side of the highway, I've dotted in yellow. Those are the fixtures that are on site that will be relocated. The dots that are on the south end are a mixture of new fixtures and old fixtures. So the purpose of coming here before you today is the Scenic River Overlay District came into play after the river improvements were made, thus reducing the requirements for the height, or the allowance for the height, and we would like to maintain those same type of fixtures throughout the project. So we're here on behalf of the city to request that be varied.
The design committee recommended approval of this yesterday.
Move approval.
I have a motion and a second. Register your vote. You are approved.
Thank you.
Thank you.
Item number 4, case number 13512, request of Oklahoma City Public Schools for a variance to the maximum number of accessory signs allowed per street frontage located at 4300 North Post Road.
Do we have the applicant present? Your name and address for the record, please.
My name is Cale Wilson. I'm with Design Architects Plus. We're here representing Oklahoma City Public Schools.
Speak to your application.
Yes, we're requesting to install 2 signs. I guess right now they say we cannot have a marquee sign as well as signage on the building on the same elevation. During the Match for Kids remodel, we wanted to replace the signs above the main door. We're just replacing a sign that was already there with new lettering. I think you have some drawings in your packets that really show the elevation. We didn't change the name. Still says Green Pastures Elementary, just as it did before.
Is there any protesters?
Any protesters present?
Make a motion to approve.
Second.
I have a motion and a second to approve. Register your vote. You are approved.
Item number 5, case number 13244, request of Doug Friesen for extension of the time period approved for completion pursuant to an order of the board located at 524 Northwest 17th Street.
Doug Friesen, 1309 North Chartel, attorney for Burton Mary Bowman. I believe that when we were here last time, you had sent the item back to the Historical Preservation Commission so that they could relook at the windows and make any suggestions they might have. We met yesterday. They approved one of the items. 2 of them were not properly placed on the docket, so we're going to have to revisit those, and the rest of them they once again denied, and they made some comments on some of them, and I'm sure Ms. Talley can elucidate that much better than I can.
All right, then let's invite Catherine Montgomery, if she will, and she can go through with the board members the packet that we've just been given.
Okay, we prepared for you a packet. Of course, these are draft minutes because the meeting just occurred yesterday. Going through each one of those items. The next item in the package that I've provided for you today are photographs as of January 27th. And then, just to refresh everyone's memory, what the property looked like on August 4th when we kind of got started under this process. Then I've included the staff report that was provided to the Historic Preservation Commission for their hearing yesterday, including photographs and drawings so that they could compare the items that were provided or that were under review. For the first item, which originally appeared as 4 items, it was kind of compressed into one because they had similarities, and this was all for the second-story windows on the south side of the property on the back, the south side of the addition, that were a smaller size than what had been proposed in the drawings that the Board of Adjustment had approved for the addition. You can see from the minutes, or the draft minutes, some of the comments that the different commissioners had to make, and their recommendation to this body. The second item had to do with the back door, but since staff had not included the word door in the agenda, we were advised by council that the back door should not be considered, but the windows of the door and the side light could be considered, which was kind of okay because that was the primary issue, having to do with the curved top of the door and the side light. Again, the commission reviewed this item, and their recommendation is the same as it was before. The third item had to do with divided lights that are on the back, what we're calling a picture window. And again, the commission went with the same opinion that they had from the previous time. And then the fourth item had to do with the divided lights on the two large windows that are on the east side. Those were surface-applied muntins, and the property owner has removed those. Based on that, the commission recommends that item to the Board of Adjustment. And then item number 5, which had to do with the brackets, was something that came up at the last time the Board of Adjustment met. And because that was not in the description that staff had provided on the agenda, we were advised by council to not consider that item. However, photographs that were provided to the commission have also been provided to you if you desire to look at those.
I would invite the board members, if they've got any questions for Catherine, to go ahead and ask them now, and then we'll invite Mr. Friesen back and then give Mr. Dell an opportunity to respond.
Well, it's my understanding that we're looking or debating on whether we're going to grant an extension to the previous order. Do you have any objection?
I don't have any objection to an extension of time.
When will item 5 be considered?
For the HP Commission, if the Board of Adjustment desires us to hear that again, the soonest would be March 7th.
Any other questions for Catherine at this time? Mr. Friesen, if you don't mind, let me invite Mr. Dell to share his comments. Mr. Dell.
My name is Brian Dell. I live at 528 Northwest 17th Street, which is the property immediately west of this subject property. The board doubtlessly is terribly familiar with this project. The initial drawings that were made on this were made in 1998. The ones about which are in front of you now were drawn in 2008. We're here today on another application, probably the 7th application, I guess, for a continuance of this matter. Here's kind of the problem with this, and that is that this was sent back by the board to the Historic Preservation Commission whenever you all looked at it and you saw that the windows did not match the drawings. And you sent it back in spite of the fact that the Historic Preservation Commission had originally said that they were not consistent and therefore they had denied it. You sent it back for one more look for them to do it. They again made exactly the same decisions that they did originally and denied this as being not consistent. The only thing that they approved was those windows on the east side for which they took the border off and they're no longer divided lights. This matter has been going on for 14 years and it's not getting resolved anytime soon. And the only thing that they did was that Mr. Friesen managed to correct one of the items instead of all of the items that were on here. You know, the supports for the roof are not really very consequential. It's the fact that this entire construction, this entire project is not historic, and the Historic Preservation Commission agrees with that it's not that way because of these various items that are before you. The only thing that can be done to make this actually ever get done in my lifetime, and I'm no spring chicken anymore, is that it's going to have to be the determination already made by the Historic Preservation Commission and hopefully by this board today to deny any further continuances. It's the only motivation that anybody seems to have. This thing has been continued, as you may note, from 2010, and it still isn't done. So I would ask you to deny any further applications, and hopefully this will somehow get done. Thank you.
Thank you for your comments.
Just a couple of questions, Mr. Dale. If this board was to deny the continuance, what would you see happening next?
Well, I suspect that because of what's happened in the past, that they would appeal to the district court. It's right over there. I don't know where it is. I'm more than happy to see that happen.
All right, and in your mind, would that allow Mr. Friesen an additional amount of time, a long period of time to deal with this problem?
Well, as has happened in the past in this particular case, and Ms. Talley knows as well as anyone, and that is that you all make an order, he appeals it. He's the only one who's lived there, by the way, for the last 14 years. He appeals it to district court, and at that period of time extends. And then, by agreement, it comes back here. That's a double continuance, because here we are today in February of 2012 from projects that have been going on for the last 2 years. Let's get it resolved in district court if that's what it's got to be.
My concern is if the continuance is denied and he appeals, this process goes on for many, many, many more months. And so I guess the question I have, Rita, is do we as a board have the ability to recommend to the city council that the city take action and file some type of suit for public nuisance to make this thing move faster instead of slower?
You have authority in Chapter 59, allows the planning director to, I'll read what it says. It's at Section 59-3550, paragraph A2, and it says, and I'm shortening it, the planning director shall have all necessary authority on behalf of the city council to bring, in concert with the municipal councilor, legal action to ensure compliance with the provisions, including injunction, abatement, or other appropriate action or proceeding. And that's compliance with Chapter 59, which is the portion of the code that the Historic Preservation Commission and all of the guidelines about what is supposed to happen. Those are all in Chapter 59.
So how would we accomplish that? By putting it on the next agenda?
You could do that. You could ask the staff to visit with the planning director about that, and you could have an item on your next agenda to accomplish that by motion.
Is that something you've thought of before, where the city takes action and files suit for a public nuisance? We put that on our agenda and grant the extension, see what happens with the Historical Preservation Group.
For 2 weeks? Is that when it would be, in 2 weeks?
When does the Historical Preservation Group meet next?
Well, they don't meet for another month.
They meet the first Wednesday of every month, so I think Catherine said March 7th would be their next date. So your meeting after that is March 15th.
We'd have to continue it to March 15th. But I could ask the board to put on the agenda the consideration of recommending a public nuisance action be filed by Oklahoma City.
Well, that would be one method, and I certainly agree that that would be an appropriate way to do it. The other one might be, and Ms. Talley may confirm this, is that if indeed there was a suit, an appeal taken across the street, excuse me, that the city could, as part of a cross-claim, come in with that same action.
Well, actually, our office would be representing on appeal the Board of Adjustment, and we would be the same office, so we would likely just pursue the one action.
I'm sorry?
We would pursue just the one action. We would be legal counsel for the Board of Adjustment on appeal, so we would likely pursue either the appeal or injunctive relief. We could roll it all into the appeal and ask the court as part of the appeal for that kind of remedy. But we would not likely pursue both.
I'm concerned the district court may not have jurisdiction to hear additional claims besides the appeal, and so that's something we would have to look into.
I think we could look into it, but I think that we could certainly file a motion to enter once an appeal was filed to speed things along, if that's a concern.
Just talking out loud, one idea would be to continue this to the 15th, take care of the bracket problem on the 7th, put on the agenda on March 15th the consideration of recommending that a public nuisance action be filed. Is that something that you would be amenable to?
It would be, that would be amenable. There's another alternative.
I think it would move faster instead of slower that way.
I believe that you're correct.
I'd make a motion that we continue until March 15th, that we submit to the Historical Preservation Committee the missed item on the brackets, and that we put on the March 15th agenda the consideration of asking the city to file an expedited public nuisance action.
Second. We have a motion and a second. My only request of the other board members would be that we'd be allowed to have some further conversation with Mr. Friesen before we dismiss ourselves, but I'm willing to go ahead and entertain the motion. Register your vote.
So, Board Member Stonecipher, you had 3 items. One was to continue the item to March 15th, remand the one roof bracket item to the Historic Commission.
Are there any other items to go before the Historic Commission other than the bracket?
Not that I'm aware of. The door itself, but I think what Catherine Montgomery said was that they pretty much took care of that with the window portion.
Is that taken care of, Catherine?
So we could put the door on just to...
In my opinion, it is, because the objection was to the configuration of the window within the door, not the door itself. I don't think so.
And then the third item was for public nuisance, is that correct?
Let's put it on the agenda for our March 15th meeting as to whether we would make a recommendation to the City Council or the appropriate entity that the city file an expedited public nuisance action on this property.
Okay.
Does that make sense?
I just want to make sure I have that.
Mr. Friesen,
Yes, sir.
care to respond?
I don't know that anything I could say is going to make a difference. You've already made your action today.
Well, what is the time frame that you all are looking for? I mean, I haven't been sitting on the board very long, but I share some of the frustrations having looked at the record. But what is the time frame that you all are looking?
I think there's some misunderstanding. The work is done. The problem now is that part of the work that was done was not in compliance with the drawings that were submitted to this group. They're up until yesterday, and the work had been done for a number of months. Up until yesterday was the first time that we had any recommendations. I've got to talk to my clients in terms, so the real issue right now is whether or not they are willing to make changes to those items that have not been approved, or for one side or the other to proceed, because it isn't like the work isn't done.
But it's not done in compliance, though.
It's not done in compliance with the plans that you approved.
Okay, so then I would say that that's incomplete then, but that's it. I just feel like, this seems like the never-ending story that...
Well, and there is some truth to that. However, I will say that this was begun as a result of the Bowman's previous attorney being requested to write a letter, and that letter was construed as a motion for continuance, and there hasn't been any other motions for continuance that have been requested since that time. What has happened is Ms. Montgomery was asked to have a list of items that she felt were not in compliance, and we've simply been working to alleviate as many of those as possible.
Okay.
When do you anticipate that you will be talking to your clients?
This weekend.
Would you please call Rita after you have spoken with them and let her know whether they plan on attempting to comply with what Historic is requesting of them?
The only problem that I have in answering that question, yes or no, is I'm not exactly sure, after attending the meeting yesterday, exactly what they want done to alleviate some of the problems. For instance, and I have gotten together with Catherine, I'll be happy to get together with her again, and if she has an understanding of what they want, that's great. Then I can do that and I can get you an answer. I don't know that I can get together with her before this weekend so that I can fairly present it to my clients.
We just want to be prepared on the 15th. And so if you could, in a reasonable time, let Rita know what your client's position is on this, that would be very helpful.
Yes, sir.
Any other questions or comments for Mr. Friesen? Thank you, sir, for attending. Mr. Dell, did you have one more comment you'd like to make?
I may, very briefly. The recommendations are not consistent are on those minutes that were presented from the hearing yesterday. In fact, they state that those particular items, the windows on the historic home do not match the additions in window size or proportion. Spacing is not consistent. Windowsill and head height do not match. That's the problem. You know, this, when it was presented to this board and sent back, the Historic Preservation Commission originally denied it, and they denied it again. Mr. Friesen told you at the hearing, whenever you sent it back to the Historic Preservation Commission, that he wasn't going to change these windows. And I think that he understands that that's what needs to happen. And so the 15th then of March will be fine. Thank you.
Catherine, one more question. Is it your understanding that the client's decision is whether they're going to replace the windows or not? Is that the issue?
I think part of the complication is that the Board of Adjustment overturned a decision of the Historic Preservation Commission, which was to deny the addition. So the Board of Adjustment said, yes, do the addition, and it needs to be done in accordance with these drawings. And when it wasn't done in accordance with those drawings, the items that I was able to pick out that were different, those things went back to the HP Commission to ask if they were consistent with the guidelines. So I think the Commission has reached a point where they're not going to change their mind.
They want the windows changed out to match the drawings, correct?
Actually, they have not said what they want, because that wasn't the question that they were asked. The question they were asked was, in their opinion, is it consistent with the guidelines? And their response to the Board of Adjustment is no on these remaining items. So that would imply that they desire some change, but they haven't given any direction as to exactly what that change would be. I mean, he could propose any number of design alternatives.
Can we make one more motion, and that is that Historical give us recommendations on how these windows need to comply with the drawings at their next meeting? Is that something we could ask?
You could ask that. They told you that what is not consistent with the guidelines, and they've given you information on specifically what would make them consistent with the guidelines, so I'm not sure.
Then that's not necessary. Okay. All right.
Yeah.
Thank you.
Did you all have a vote already on this motion? I didn't remember.
Yes.
You did. I remember the motion in the second.
Yes.
My problem here is just exactly as Catherine has said. There isn't anything I can take to my clients, but no matter what is happening, and while my clients have to stand responsible for the design difference, the last 2 times that this has gone back to the Historical Preservation Commission hasn't been their fault in terms of requesting continuances or anything else. But they're still getting blamed for it. They're getting blamed for it in terms of the time-wise. They're getting blamed for it by Brian Dell. in reference to it. So if we are thinking about batting this back and forth from that perspective, at that point, my clients would just assume you say, this is denied, your request for continuance is denied, and then we're done. And this all came about from a letter report that was not really a request for continuance.
So Mr. Friesen wants clarity in terms of what his homeowners would have to do to be compliant.
It seems pretty simple to me. He submitted drawings. His windows are not in compliance with those drawings, and now his clients need to put in windows that meet those drawings. And we need to know whether they're going to do that or not. And if they're not going to do that, that's fine, tell us. But if they're going to do it, we need to know quickly.
So the request for clarity, the request for clarity is that the drawings that were submitted and approved by this board are, you do that and you're compliant. Am I correct?
Based on the Board of Adjustment's decision, I would say yes.
There's your answer.
Fine. That I can get you an answer to.
Okay. And if there's any ambiguity, call Rita, touch base with Catherine, but I just, we'd like to be, as Mark said, we'd like to be prepared for the 15th and have a sense of which direction we're going to go.
And Mr. Friesen, as far as the extension of time, the reason that came up was because there is some dispute about when the time ended that the board initially granted. We believe that it was 6 months that ended in December. That was extended through to June. And then at that time, this board was asked for additional time. So it was something that was done by a previous council asking for additional time. It wasn't this body on its own saying we're going to drag it out.
The one other additional request for clarification I would have is, what about those items that have been approved by the Historical Preservation Commission that are a deviation to the plans, but they have been approved by the Historical Preservation Commission?
The question to the Historic Preservation Commission was, were these things consistent with the guidelines or not? And then they made a recommendation to the Board of Adjustment saying, these are things we would recommend to the BOA, and these are things that we would not recommend to the BOA. So I think that decision was kind of in the BOA's hands, and certainly if the BOA is willing to go along with the HP Commission's findings that these things are consistent, then they could grant that those things could remain.
So on those items, there was a discrepancy between what actually occurred and what the drawings showed should occur, but HP has recommended to us that they would recommend that they be allowed. And so it would be an action on our part to address those particular items.
And perhaps we could get that from HP staff, exactly where we are right now. If we don't already have a clear list of that information, what else is there for this board to consider? Could you prepare that for the
The minutes from the last meeting, I didn't bring those with me. I'm
No,
sorry.
for the March 15th meeting, could you provide a report that lets this board know exactly where we are in terms of what was appealed, which was just the rear addition, as far as what HP has approved and what they have found to be inconsistent with the guidelines?
Yes, I can summarize those items.
Would that be helpful to the...
That would.
If I heard you right, Mr. Austin, you're telling me that I should only inquire of my client about those items that have not been approved or recommended by the HP Commission.
I think, that's probably fine to have that conversation. I mean, I speak for myself and not for the rest of the board, but I mean, I would expect that the board's going to take into consideration HP's recommendations on what might be consistent and what we might consider approving. But again, I'm speaking for me and not for the rest of the board. But I think in terms of the conversation with your client, that's probably an appropriate conversation for you to have, as outlined.
Yes, sir.
Any other questions for Mr. Dell, Mr. Friesen, or Catherine Montgomery? Thank each of you for your attendance today. Thank you. Could I ask someone from staff to, okay.
that what you want?
We might be on the verge of an agreement if we could wait like 3 or 4 more minutes.
Take your 3 or 4 minutes.
Thank you. I think maybe Mr. Hugus would like to speak first.
After some lengthy discussion, we believe we found common ground, and as a result, I am speaking on behalf of the Homeowners Association, and with respect to the well that is the subject of today's council meeting, the Homeowners Association of Bradford Place Estates removes its opposition previously presented.
Thank you, and thank you for your effort in trying to find a resolution that both parties could live with. Thank you.
It might be appropriate to ask whether any individual homeowner apart from the homeowners association is still protesting. That might be the case, but I don't know.
I would ask
sure,
that
and I don't
question.
want to take advantage of anything.
Are there any other homeowners that are here to hear this case that have a position different than what Mr. Hugus has outlined?
No, sir, there's not. The other individuals who are with us are in agreement.
Could I ask you to come to the microphone, please? I'm sorry. And if you would, give us your name and address and then start over, please.
I'm Catherine Hugus. I'm the president of the Homeowners Association, 4100 Southeast 86th Place. The other individuals that were with us, they obviously have also a vested interest, but they also understand the need for us to act as a group. And they are not protesting individually, and they have given us their word that they will not protest individually outside of the agreement, and the Homeowners Association acts as one.
Thank you. Do we have any more comments or questions for Mr. Walker before we entertain a motion?
Go ahead.
I would make a motion to approve case number 13504.
Second. I have a motion and a second. Register your vote. You are approved.
Thank you all very much. Appreciate your
And I
patience
would
with us.
express my thanks to the neighborhood for working toward a resolution on this and wish you all well. Motion to adjourn?
That's possibly my last official act on the board.
Motion to
Can I say
adjourn?
that now? Motion to adjourn?
Do we have a second? We are adjourned.